Welcome to The Deep Dive. Today we are pulling back the curtain on New York City. Not just famous as the Big Apple, but maybe infamous now as the epicenter of this costly legal breakdown that our sources are actually calling the Fraudemic.
Yeah, that term fraudemic, it's unsettling, but frankly, it seems pretty accurate based on the research. We're really moving beyond just general stories about lawsuits here.
Right.
We're looking at what seems to be rampant lawsuit abuse that is systematically overwhelming the civil justice system, particularly in New York. And at its core, this fraudemic, it kind of exposes how these unique state laws are being exploited.
Exploited by whom?
Well, by highly organized groups, sometimes involving, believe it or not, criminal elements. And the goal, purely massive financial profit.
Okay, so that's our mission for you today. Trying to understand how this system actually works. We need to unpack the unique local laws that create the opportunity in the first place.
Exactly. Then we need to dig into the organized schemes that exploit them.
And finally, look at the staggering economic and judicial consequences, because these really hit everyone in the state, don't they? From homeowners to small business owners.
Absolutely. When you put all the data together on New York's legal climate, it paints a, frankly, bleak picture. The state is cited as a prolific producer of nuclear verdicts.
Yeah.
These huge, sometimes excessive jury awards.
We hear that term a lot.
And it's also a prime target for no-injury consumer class actions. It's gotten so toxic, sources suggest, that it's actually driving businesses and insurance companies, too, right out of the state.
Wow.
Yeah, unless state leadership steps in with some serious structural reforms, that trend looks set to continue.
Okay, let's start at the foundation then. Section 1. These unique liability laws that seem to enable the abuse. And the obvious place to begin has to be the Scaffold Law, right? Labor Law 240.
Definitely. It's, you could say, the cornerstone of the problem in construction. Now, this law, it was originally intended, way back, to protect construction workers. But the way it works now is it imposes strict liability for gravity-related construction accidents.
Okay, strict liability. What does that mean in practice?
It means if a worker falls from a height, or say an object falls on them, the property owner or the general contractor is automatically liable, 100%.
Automatically, even if the worker maybe wasn't following safety rules.
Exactly. Even if the worker was negligent, ignored warnings, whatever, the owner or contractor is strictly liable. And that's the crucial point.
Hold on, so strict liability means it's basically a guaranteed payout for the plaintiff.
Essentially, yes. And that's the insight often missed. New York is the only state left that still has a pure strict liability statute like this one.
The only one.
The only one. And that guarantee of payment, it just fundamentally changes the whole risk calculation. It makes New York construction this highly predictable, incredibly lucrative target for, well, organized groups looking to exploit the system.
And the economic impact of this single law? It's huge, isn't it?
Oh, tremendous. Estimates put it at about 10% of the state's total construction costs. Just think about that.
Wow, 10%.
And beyond the sheer dollar figure, you've got groups like Habitat for Humanity saying publicly that the Scaffold Law is a major obstacle. It hinders affordable housing projects, disaster relief efforts.
And it hits smaller businesses harder.
Disproportionately, yes.
Yeah.
Especially minority and women-owned businesses who just can't absorb that kind of catastrophic liability risk if something goes wrong.
Okay, so that's construction. But moving beyond that, we also need to talk about another law that seems to allow for volume exploitation. The Consumer Protection Act, GBL, Section 349. You mentioned its vague language makes it ripe for abuse. How?
Right. Unofficially, you could maybe call this the no-intent law. It's damaging because a plaintiff, under this law, does not need to prove two key things that are usually central to fraud cases.
Okay, what are they?
First, they don't have to show the business intentionally misled consumers. And second, they don't have to show that the consumer actually relied on that misrepresentation when making a purchase, to their detriment.
So, wait, if I buy something and I feel the label was a bit off, I don't need to prove the company meant to trick me, or even that I bought the product because of that specific label claim.
That's the core vulnerability, exactly. When you remove intent and reliance, the door just swings wide open for lawsuits over maybe the most minor, almost trivial labeling issues.
Right.
And that drives this massive volume of litigation that really benefits the law firms filing the cases, not necessarily the consumers themselves.
Okay, and one more before we move on, just briefly, the no-fault auto system.
Yeah, New York's a no-fault state for auto insurance. This means insurers have to pay for medical expenses and property damage regardless of who actually caused the accident. Right. That mandate, plus the requirement for the highest commercial vehicle insurance coverage in the entire country, makes New York policies these incredibly valuable targets for, well, organized fraud schemes in the transportation sector, too.
Okay, that sets the stage perfectly. So you have these unique laws, strict liability, no intent, mandatory high-value insurance. How do the criminal elements actually exploit them? This brings us to the core, right? Section 2, the organized schemes that define this fraudemic.
And we really are talking about sophisticated operations here. Recent investigations, especially around construction liability and the Scaffold Law, they've uncovered these complex schemes. We're talking organized groups involving MS-13 members, Russian mobsters, corrupt surgeons, lawyers, even third-party litigation financiers. It's like cross-industry organized crime targeting the civil justice system.
That sounds like something out of a movie. Is there a specific example?
Well, the roadmap was kind of laid bare in that big RACO suit, the Roosevelt Road Re, LTDV Hajar complaint. That document alleges 46 individuals and businesses were systematically involved in filing false or, wildly exaggerated injury claims.
And how did they allegedly do it?
The suit detailed how these schemes often target vulnerable workers, particularly foreign-born individuals who maybe lack English proficiency. They're encouraged, maybe even coerced, into filing claims for completely fabricated injuries.
Fabricated? Like what?
Like a simple trip and fall that heals quickly gets turned, on paper, into a multi-million-dollar permanent disability claim. It's reportedly so brazen that videos have actually surfaced showing workers, pretending to fall on job sites. Staged accidents.
Staged accidents caught on video.
Yes. And look at the financial impact. For just one reinsurer involved in that scheme, their liability claim expenses reportedly ballooned from $14 million in 2018 to over $142 million by 2022.
A tenfold increase in just 4 years.
Exactly. That kind of jump doesn't happen organically. It really speaks to the efficiency of the criminal organizations involved.
And it's not just shady operators, right? Law firms themselves have been implicated.
We have to acknowledge that role, yes. One prominent firm, Subin Associates, came under intense scrutiny. They actually requested to withdraw from somewhere between 200 and 300 cases just this year, citing ethical concerns about their referral sources.
Ethical concerns about where the cases came from, that sounds significant.
It is. And it brings us to the really heartbreaking human cost of all this. You mentioned the case of Carlos Ramirez Naranjo.
Right, the man who doesn't speak English.
Allegedly, he was deceived. He thought he was signing papers for a job application, but those documents were apparently used to file a fraudulent workers' comp lawsuit for injuries he never even suffered.
So he was just used.
Completely victimized by the machinery. After he confronted the firm, the story goes, he was left with only $2,000. And that was after cashing a pre-settlement funding check and having to hand over $13,000 to the acquaintance who recruited him into the scheme in the first place.
So he ends up in debt with nothing from the supposed lawsuit.
Exactly. It shows how vulnerable people aren't just recruited, they're systematically exploited and then just abandoned, often saddled with debt.
And this kind of systematic fraud, sadly, isn't just in construction. It's hitting the auto insurance market hard, too, thanks to that no-fault law we mentioned.
Yes, very similar schemes operate there. Staged accidents, often targeting high-value commercial vehicles, think taxis, ride shares, and again, you see the alleged involvement of corrupt doctors, lawyers, and funders.
And the consequences are potentially massive there, too.
Huge. It's pushed American Transit Insurance Company, ATIC, which insures something like 60% of New York's commercial taxis, right to the brink of collapse. They've reportedly suffered $700 million in losses, largely due to fraud and escalating costs.
Okay, so if ATIC, insuring that many taxis, goes under, what happens then? Who picks up the tab?
Well, ultimately, the New York taxpayer does. It works through something called guarantee funds. If ATIC is liquidated, the state's guarantee funds, basically pools of money paid into by all the other operating insurers, have to cover ATIC's outstanding claims.
And if those funds aren't enough?
Then the costs eventually get passed back to the state, which means taxpayers foot the bill. And on top of that, every other driver in New York likely faces massively higher insurance premiums because the remaining insurers have to replenish those funds.
It's a ripple effect hitting everyone.
Precisely. And it keeps evolving. As recently as October 2024, new RACO suits were filed, this time against pharmacies.
The pharmacies, how do they fit in?
The allegation is they're exploiting the no-fault law by directly billing insurers for expensive, medically unnecessary pain treatments, things like compounded creams, specific oral meds, And this is allegedly facilitated through kickback arrangements with certain clinics, just another angle to siphon money out of the system.
It really sounds like a concerted effort, attacking the system from multiple
It
points.
does. And that brings us to Section 3. How does all this fraud and exaggeration actually translate into those shocking, massive jury awards we talked about earlier? This is where nuclear verdicts really come into play.
Okay, define nuclear verdict for us again. It's not just any large award, is it?
No, it's generally defined as a jury award that's truly massive, one that significantly exceeds what might be considered reasonable or proportionate to the actual damages or injuries involved. And New York is definitely a hotspot.
How much of a hotspot?
Between 2013 and 2022, it recorded the third most nuclear verdicts in the country, 131 of them. And on a per capita basis, it was second highest nationally. The median nuclear verdict in New York during that time, $20 million.
The median was $20 million. That's incredible. So how do lawyers actually get juries to award sums that high? Is there a specific technique?
A key factor is a tactic called anchoring, and it's specifically enabled by a technical bit of New York law, CPLR 4016B. This rule actually allows the plaintiff's lawyer, during closing arguments, to request a specific dollar amount for damages.
They can just name a huge number. How does that work in practice? Give us an example.
Okay, so imagine the lawyer stands up in front of the jury and suggests that the pain and suffering alone is worth, say, $140 million. That's a real figure cited in the sources, by the way.
Right.
That number, $140 million, gets planted or anchored in the jurors' minds. Even if the jury thinks, okay, that's too high, and maybe scales it back to, say, $40 million, well, that $40 million is still likely far, far higher than they would have ever considered if they hadn't heard that initial astronomical figure first. It fundamentally shifts the baseline and drives up the award.
And we're seeing the results, right? Just this year, a $72.5 million negligence verdict in March, and that huge $287 million product liability verdict in August.
Exactly. And this anchoring tactic, combined with a no-intent consumer law, also fuels the sheer volume of no-injury class actions. New York is arguably the national capital for these. Get this. 25% of all national food and beverage class actions filed in 2023 were filed right here in New York. 47 suits.
A quarter of the national total. And some of these claims sound almost frivolous.
Some are borderline absurd, frankly. It brings us back to that no-intent law, GBL Section 349. The sources mention lawsuits like one claiming Velveeta mac and cheese is misleadingly labeled made with real cheese because, it also contains other non-cheese ingredients.
So because it's not 100% cheese, it's misleading.
That's the argument. Or consider the claim that a can of Campbell's soup has too many potatoes and carrots to justify listing beef first in the product name.
That almost sounds like satire. But these are real lawsuits clogging up court time and costing companies money to defend.
Exactly. It really highlights the financial motivation. For many businesses, especially smaller ones, it's often cheaper just to settle these frivolous claims than to spend potentially millions proving that no reasonable consumer was actually misled.
And this settle to avoid costs model, that applies to AD litigation too.
Perfectly. And New York leads the country there as well. 2,759 federal ADA lawsuits filed in 2023. Plus, New York state laws are even broader, more expansive than the Federal Americans with Disabilities Act.
We heard some pretty staggering numbers about specific law firms filing these ADA suits.
Yes, the abuse model seems to rely on what are called serial plaintiffs and a few specific law firms filing floods of lawsuits. Judges have called the allegations in these suits vague and conclusory. They often target small businesses over maybe minor website accessibility issues or physical barriers.
And they count on the business just paying up quickly.
They rely entirely on the business settling fast just to avoid the potentially massive cost of defense, even if the claim itself has very little merit.
And you mentioned one firm, Mizrahi Krub, filing over 1,000 of these in a year.
Over 1,100 web accessibility lawsuits in the last year alone. That's about a quarter of all digital ADA cases filed in the entire country, from just one firm.
A quarter of the national total from one firm. What does that tell us about the system?
Well, it suggests the system might be structured in a way that rewards sheer volume over the actual merit of the claims. We even saw a federal judge in the Southern District of New York, Judge Mary Kay Viscoso, publicly call out another firm. She noted they filed 10, basically carbon copy accessibility lawsuits against different defendants all on the same day.
And what happened?
She dismissed the case before her, stating the plaintiff hadn't shown a real and immediate threat of repeated injury. But the fact that these suits are filed so routinely in such volume That's the core of the problem.
Which brings us, I think, naturally to our next section. Section 4, systemic complicity. If the fraud is this organized, this widespread, and the volume of questionable litigation is this high, why isn't the system doing more to stop it?
That's the troubling question. The sources we reviewed allege a pattern where judges sometimes appear to turn a blind eye to clear ethical red flags. For example, allowing personal injury firms to simply withdraw from hundreds of suspicious cases like the Sobin Associates example, with seemingly very little investigation into the potential underlying fraud, and few, if any, consequences for the firms themselves.
Let's go back to Leslie Ortiz again. Her story seems central here. She was referred to Sobin Associates, had unnecessary surgeries, reported terrible pain.
And when her case came under scrutiny, the judge allowed Sobin Associates to just be relieved from the case, citing those ethical concerns from the firm. The tragic outcome for Ms. Ortiz: she never received a dime from the lawsuit itself, but she was left thousands and thousands of dollars in debt to a third-party lending firm.
Debt for money she borrowed while the case was ongoing.
Exactly. Money for medical bills, living expenses, advanced against the expected settlement. That's where third-party litigation financing becomes so potentially toxic in these situations.
So the lawyers walk away, potentially avoiding scrutiny for fraud, but the plaintiff is left holding the debt.
That seems to be the pattern in some of these cases. The financing firms lend the money. When the lawyers are allowed to withdraw from suspect cases, their liability effectively ends. But the plaintiff, often the vulnerable person recruited into the scheme, is left holding the bag, still owing thousands to the lender. And when judges don't rigorously investigate why the lawyers withdrew, it arguably perpetuates this cycle.
And this status quo, this environment favorable to high-volume litigation and maybe lax oversight, it isn't just accidental, is it? There's a political dimension.
A significant one, according to the sources.
Yeah.
Plaintiffs' law firms have reportedly poured more than $4.7 million into New York political campaigns just since 2017.
$4.7 million. To what end?
Presumably to ensure the system remains aligned in their favor, to maintain the status quo. Nearly 70% of those contributions allegedly went directly to LawPAC. That's the Political Action Committee affiliated with the New York State Trial Lawyers Association. That kind of money buys significant lobbying power, making it very difficult, for instance, to achieve reforms of strict liability laws, like the Scaffold Law.
It sounds like a powerful feedback loop, ensuring the Fraudemic, as they call it, can continue.
It certainly looks that way.
Okay, so let's try to synthesize this for everyone listening. What we're seeing is New York's unique legal landscape, especially the guaranteed payouts under the Scaffold Law and the no-fault auto system being strategically weaponized.
Right. Weaponized by organized, sometimes criminal schemes. And this situation is made worse, or at least perpetuated, by a judicial environment that sources suggest has been reluctant at times to hold the law firms and serial plaintiffs fully accountable for potential abuses.
And the outcome. It's like a hidden tax on every single resident, isn't it? Dramatically higher insurance costs, which feed into increased housing costs, soaring workers' comp rates.
Exactly. The justice system itself is under extreme strain, clogged with questionable cases, and ultimately it's everyday New Yorkers who are paying the price.
So, to leave you, our listeners, with a final thought to chew on, we're now seeing potentially new forms of liability emerging in New York courts, and these could completely redefine corporate responsibility, especially in this already volatile environment.
Yeah, this is fascinating and maybe a bit scary. There are these novel liability cases working their way through the system right now. For instance, a New York court recently allowed a product liability theory to move forward against Meta platforms, Google, and Alphabet.
Product liability against social media companies. For what?
Regarding a school shooting, the argument essentially is that the defective and unreasonably dangerous design of their platforms, their products, facilitated the shooting. This is apparently the first time a court has allowed this specific product liability theory against a social media company.
That sounds groundbreaking and potentially huge.
It is. And there's also that wrongful death suit against Meta and TikTok concerning the tragic death of a teenager participating in the viral subway surfing challenge.
What's the claim there?
The allegation is that the platform's products actively goaded and encouraged this dangerous activity. So when you take these new, really expansive liability theories,
And you combine them with a legal environment that already has anchoring tactics, nuclear verdicts, maybe lacks oversight.
exactly, it raises this really crucial question for the future. Just how far will New York courts go in redefining corporate and platform responsibility, particularly in the digital age. That's definitely the next frontier of legal risk we need to watch very closely.
Something for all of you to mull over as you think about the complex economic and legal forces shaping New York and potentially the rest of the country. Thank you for joining us for this deep dive.